If you're worried about being prosecuted for a white-collar crime, or about your company or its officers or employees being prosecuted for a white-collar crime, there's some good news. White-collar prosecutions are at their lowest level in 20 years, according to a clearinghouse that tracks such things. New white-collar criminal filings are down a whopping 40% since 1998. The bad news is that in 2017, this still means prosecutors brought nearly 6,000 new white-collar cases. In 2017, the average federal sentence for individual defendants in federal white-collar cases, this is in round numbers, was 23 months in prison, $1.4 million in restitution, and a little over $5,000 in fines. Now, if you eliminate cases where the court imposed no prison time, fines, or restitution, those numbers jump up to 34 months in prison, $1.7 million in restitution, and $64,000 in fines. Credit to the good people at sentencingstats.com for helping to distill those figures. Although organizations can't do time, companies charged with crimes faced stiff financial penalties in 2017. According to the U.S. Sentencing Commission, in federal cases where courts sentenced companies to pay a fine based on a fraud offense, the average fine amount was $129 million and the median fine was $1 million. And those figures don't account for the various collateral consequences of conviction. Anyway, there are few things that clients fear more than criminal prosecution. After 2 decades of doing this sort of work, I can say that's with good reason. Being prosecuted can ruin lives, reputations, finances, both corporate and personal, marriages, and families. This photo is of former Enron CEO Jeff Skilling doing the perp walk in Houston after his arrest. Skilling was convicted at trial in 2006 for criminal fraud and was sentenced to a 24-year term and a $45 million fine, eventually reduced to a 14-year sentence based on a groundbreaking U.S. Supreme Court decision that bears his name. He was released just this year from prison to a halfway house. In the same investigation, as a young lawyer, I represented the wife of Enron CFO Andy Fastow, who was prosecuted along with her husband. No one in that family will ever be the same. This is a photo of an FBI agent carting boxes of documents out of Solyndra, following that innovative solar company's bankruptcy. Because the company had received a first-of-its-kind $530 million loan guarantee from the federal government, its subsequent failure led to congressional and criminal investigations that became an issue in 2 different presidential elections. This picture was all over the news the day the feds raided Solyndra and for many weeks thereafter. I represented a former senior officer in that investigation. Although the DOJ never charged anyone and the targets of the investigation have all moved on with their lives, I could tell you with confidence that it was hell for them for all of those years. Besides the fact that prosecutions are significantly down nationally, there's some other good news. There actually are things you can do to minimize the risk of a criminal investigation, and if your company is investigated, to mitigate the impact so you and your clients can avoid FBI raids and perp walks and try to stay off the front page. Today I'm going to cover 5 lessons learned from my decades working on criminal investigations. I'm going to start with tips on how to avoid criminal investigations in the first place and end with some thoughts on conducting internal investigations, a topic that would need its own presentation to do it justice. In between, I'll cover how to respond to grand jury subpoenas and criminal investigations generally. I'll also spend some time on surviving search warrants and how to handle the press. First, let me cover some background. I divide the world into 2 major types of investigations. First, investigations by government agencies and prosecutors, and second, internal investigations. Companies often conduct internal investigations in response to government investigations. Now, let me be clear on what I won't be talking about today. I'm not talking about routine regulatory oversight, which can sometimes be very intrusive and occasionally lead to criminal investigations. I'm focused today on investigations that could directly lead to prison time, major fines, and other crippling penalties for culpable individuals and companies. These kinds of investigations are usually initiated by agencies like the FBI, the U.S. Postal Inspection Service. Yes, they cover mail fraud, which is one of the most frequently prosecuted forms of white-collar crime, and the IRS's Criminal Investigations Division. The SEC's own investigations sometimes spark criminal investigations. In any event, these investigations will, if they have legs, find their way to the DOJ and its local U.S. attorneys' offices across the country. And of course, state attorneys general and district attorneys launch white-collar investigations too. With that background in mind, let me turn to the first lesson I'd like to impart. An ounce of prevention is worth a pound of cure. The best kind of a government investigation is one that never happens in the first place. How do you ward them off, or at least mitigate the pain of an investigation and avoid prosecution? The place to start is with a robust compliance policy. The contents of such a policy are beyond the scope of today's presentation and must be tailored to each company anyway. That said, what you need are policies that exist on more than just paper. Having a compliance policy that lives only on a website or on an internal share drive or an employee's onboarding documents really just isn't enough. You and your colleagues need to scrub the policy, making sure it actually works for your personnel. You have to ensure that personnel, from the most junior to the most senior, not only read, but understand compliance policies. You need to hold trainings. You need to test their knowledge, literally test it. If your company's employees fail, retrain them and test them again. And if they fail again, consider penalties. The DOJ's charging and sentencing policy focuses substantially on tone at the top and how deep problems run. Testing your employees' understanding of your compliance policies is one way to find out in advance. Speaking of tone at the top, make sure your senior management are clearly and openly behind your compliance efforts. Have them communicate to your employees the importance of compliance. Here's an example of tone at the top in trouble, dealing directly with a compliance policy, in this case, the policy pertaining to insider trading. In case you don't know him, this is Stephen A. Cohen, the founder and former head of SAC Capital, once a $16 billion hedge fund. SAC was eventually forced to plead guilty to charges of insider trading, forced to shut down, and pay nearly $2 billion in fines and penalties collectively in the criminal and SEC cases brought against it. At least 8 of its executives pled guilty or were convicted after trial. Long before that happened, Canadian insurer Fairfax Financial Holdings sued SAC Capital and Mr. Cohen for conspiring with other hedge funds to spread false information in an attempt to drive down Fairfax's stock price. I'm going to show you a video clip from a deposition of Mr. Cohen taken by Fairfax.
The following restrictions, which include the restriction on not passing on material non-public information, must be strictly adhered to. That is inconsistent with what you've just described as what your policy is, correct?
You know, when you take a paragraph out of context, I really take objection, and because I look at this as a manual, okay, and it's a manual of guidelines.
Okay, and this guideline is that the following restriction must be strictly adhered to. So it doesn't have to be strictly adhered to. It can be adhered to sometimes, and sometimes, if you've got good judgment, it doesn't need to be adhered to, right?
Object to the form.
The vast majority of the time it is adhered to. But there are times when I can think of situations when it doesn't have to be.
Okay, but this doesn't say the vast amount of times, most of the time, some of the time. It says strictly adhered to. The fact of the matter is that language is not consistent with the practice inside SAC as you've described it, right?
Object to the form.
In my mind, we're talking about judgment.
So you don't have to strictly adhere to it. You can adhere to it in your judgment. Is that fair?
Object to the form.
In my view, employees adhere, and sometimes strictly adhere to this, but because of their experience and their ability and their judgment, they might. I'm not saying they would, but they might, because of their experiences, and they've been in that situation before, they know how to act.
Well before SAC went down, the former SEC chairman, Harvey Pitt, came to SAC to present to the firm's traders, analysts, and portfolio managers about insider trading. Mr. Cohen did not attend the presentation. Talk about a sign and signal about the importance or lack thereof of compliance. Quote, "My sense was that it was a check-the-box mentality," Pitt once told a New York Times reporter about SAC. Many organizations are staffed with experienced professionals who don't have sufficient authority or who aren't incentivized properly to address the most significant issues. If you don't think your principals take compliance seriously, then your organization won't either. I'm going to talk now about email, the greatest source of evidence, both inculpatory and also exculpatory, in modern white-collar cases. No one has great email hygiene. Understand this and get your people to understand this. Have them learn to write as though a New York Times reporter is on the to line of every message. You should also get in this habit. As someone who has spent much of his career reading other people's emails, I can tell you that almost no one follows this basic principle, and I can nearly guarantee you your employees don't. Indeed, they probably write things that would make you cringe and a prosecutor salivate. Although I'm pretty constrained by the types of cases I work on, from identifying clients and details too clearly, I can say that we recently spent years and millions of dollars convincing the government not to prosecute a client whose emails were chatty and loose and, however, concerned subjects that were complex and nuanced. My client never thought for a moment that these messages, sent at all hours of the day and night from all over the world, would end up being reviewed by anyone other than their intended recipients. It took us incredible effort to understand the context of the messages that the government initially thought proved an elaborate, coordinated fraud. To do so required reading zillions of other emails, the ones the government didn't notice in their review, talking to the client, and studying the industry at that time. What a pain. What stress for the affected individuals. Here's an example of what I would call a bad email from one of my cases. Explainable ultimately, but bad. It's heavily redacted, but you get the gist. Here, an investment banker was seeking pretty specific, detailed information from a senior corporate officer for the sake of a discussion with the board of directors in advance of a significant corporate event. The banker essentially asked the officer whether things had changed at all from a presentation the banker had given to investors on a prior occasion. Quote, "Should the answers to this be factual?" asks the officer. Ugh. When he wrote that, at what I think was 1:10 in the morning, and this is a guy who typically woke up every morning at 4 a.m., he gave it not even a moment's thought. And he certainly didn't think that it would end up in the hands of federal agents and prosecutors. After digging into the context and interviewing the officer at length, it became clear that he didn't mean, quote, "Should our answers to this be accurate?" Or, "Is it okay if we lie to the board about these significant pieces of information?" But that's what the feds, who in the main are a skeptical, beady-eyed lot, sure thought he was asking. Instead, what he meant was, should the answers to this be detailed? Detailed. I was able to show this by pointing out to the government that later that day, well after the sun had risen, the same officer forwarded the banker's request to another senior officer, complaining about the banker's question, saying that the bankers already had the latest information and that should have told them that the numbers were different. In this subsequent email, he offered the other officer literally pages worth of figures that were potentially responsive to the banker's request. I pointed out to the government that the author of the "should the answers to this be factual" question was someone who struggled with being succinct and focusing on the big picture in the role he was serving at that time. I also showed the government that it was the other senior officer who ended up talking with the banker about the questions in the banker's email, providing what that latter officer described as a medium level of detail on the points. I was able to show that the whole context demonstrated not an attempt to defraud, but rather an attempt to be forthcoming. But who wants to have lawyers forced to point any of these things out in the first place, with a potential indictment hanging over their heads like a sword of Damocles? Again, write every email like a New York Times reporter is on the to line. Preach it, practice it. This brings me to my next lesson learned from white-collar investigations. A grand jury subpoena is different from any subpoena you've ever received, so treat it that way. If you ever receive a federal grand jury subpoena, do not treat it like every other subpoena you've ever dealt with. I've seen otherwise sophisticated companies, even ones in highly regulated industries, that don't see this basic distinction and proceed at their peril, having lawyers or even non-lawyers with no criminal law experience handle grand jury subpoenas. Grand jury subpoena is not like a document request in a civil case. You may be given the same amount of time as in a civil case to respond, i.e. to produce the requested documents, but you need to be thinking about more than just producing the requested documents. One way in which grand jury subpoenas are not much different than civil subpoenas is in the area of document preservation, and I want to stress preservation here. A duty to preserve relevant documents arises when litigation is reasonably anticipated or foreseeable, as well as when litigation is pending. Failure to preserve documents can result in spoliation, leading to court sanctions and other adverse consequences. You'll want to issue a litigation hold notice to all personnel who might conceivably have documents that could be responsive to the subpoena or what you understand to be the areas of investigation. In the context of investigations, the potential risks here are amplified. You don't want to be charged with obstructing justice by destroying documents that reasonably would have been anticipated to be relevant to a pending investigation of which you were aware. If you are concerned that the hold notice might alert or alarm certain personnel, go ahead and mention that concern to the agent or prosecutor handling the investigation, who conceivably may share your concern and potentially tell you they won't require you to issue the hold notice, at least not to that person or persons. You want to get that confirmed in writing. Email's fine. Okay, let's talk about substance. Given their potential significance to the recipient, grand jury subpoenas are shockingly easy for an agent or prosecutor to draft, as I show in this graphic. But grand jury subpoenas can portend big issues. The trick is right-sizing the response, as some subpoenas, for example, may be aimed at a third party and won't implicate the company. Some companies, for example, telecom providers, deal with these kinds of subpoenas on a regular basis. But oftentimes, you won't know how close the subjects and targets of the investigation are to you and your company. A couple of points here. First, the return or response date on grand jury subpoenas will often be pretty tight, a few weeks at times. Often, you will need more time to respond. My experience is that you can typically get that time from the agent or prosecutor responsible for the subpoena, assuming that you can make a decent case for why. Second, there's not much point in serving objections to a grand jury subpoena, although you can and should withhold privileged documents, stating in your production letter that you are doing so, but I've never been asked for privilege logs. You can move to quash the subpoena, but you'll face an uphill battle in doing so. The law gives grand juries, and therefore prosecutors and agents, significant latitude to gather documents relevant to federal criminal investigations. Your best bet will be to negotiate the scope of the subpoena through a live conversation or series of conversations, which agents and prosecutors are often willing to do if you can make a good argument for why the subpoena is ambiguous or overbroad. Oftentimes, they don't want to read more documents than they have to read, and they don't necessarily have the time or resources to read big volumes. In really big cases, however, this is not necessarily the case. Anyway, the initial conversations about the scope of the subpoena are a golden opportunity to learn about the scope of the investigation. Prosecutors will likely share some information with counsel for the company regarding the basis for the investigation. Competent white-collar counsel can often suss out valuable information about the investigation in a call or two with the agents or prosecutors. This takes us to lesson number 3. Before you can respond to an investigation, you must reverse the balance of knowledge. At the outset of the investigation, the company or individuals under investigation typically know less about the facts than the government. The government has been working with individual witnesses who have shared information about the company's activities. They may have a whistleblower, a corporate insider with sometimes vast knowledge, who's been whispering in their ears, sometimes through his or her own counsel. They may have already issued subpoenas to other parties without your knowledge. Therefore, they may have already reviewed documents, sometimes many documents, before you learn of the investigation. Your number one goal in responding to an investigation, once you discover it, is to figure out what the government knows and then figure out the rest of the story, and as quickly as possible. An assessment of the facts and the threat of prosecution will often lead to the conclusion to do an internal investigation, which I'll discuss in a minute. Whether you do or don't do a full-blown internal investigation, work quickly to match, then exceed the government's understanding of facts. That will often entail at least some review of emails and other documents and interviewing witnesses, which you'll want to do in a way that allows you to preserve the attorney-client privilege and maintain the work product protection. Assuming this is an investigation that presents some risk to your company, you'll want to have outside counsel pushing for meetings with the government in person to get them to tell you what they think they know and what they may suspect. Now, your mileage will vary with different prosecutors. Some are very tight-lipped, others are much more forthcoming, especially if they trust the defense lawyers talking to them. But lawyers should be trying to convince the prosecutors and agents that it's in their interest to reveal more. That is, telling the government that they want to be sure to get things right, test out what may be a bad theory, or to vet a fact that may not actually be a fact. Moreover, If the government thinks your company or one or more of your people are guilty of something, counsel should be convincing the government that it's in the government's interest to lay out their case in some detail so as to convince you to plead guilty or cooperate against culpable individuals. They may not convince you, but at least you'll learn something in the process. Anyway, once you have a decent grip on the facts, which may take months depending on the case, and assuming your company is in the zone of prosecutorial interest, you'll want to consider whether to schedule meetings with the government to lay out at least some of your defenses, or at least address any misconceptions you believe they may have. Now, there's a risk calculus here, of course. If you think your company may be indicted and that you aren't going to be able to derail that train, you may want to keep your cards close to the vest and save your best for trial. For the most part, my experience has been that in white-collar cases, you generally don't want to keep your cards close to the vest because the consequences of indictment alone can be so grave, and so staving off the indictment is what you're shooting for. This brings us to our next lesson learned from white-collar investigations. Warrants, how to prepare and react to an unwelcome knock at the door. There are few things that can make a company's stock price dive faster and farther than press photos of FBI agents in blue jackets carting boxes of documents out of the company's headquarters. Let me cover some basic points. First, immediately call counsel. If there are others who may be the first to receive the agents, make sure they know to call counsel. Second, don't consent to search outside the scope of the warrant, that is, without consulting with counsel. Third, make sure to read the warrant and look for limits on its scope. Next, let your employees go home. Warrant execution often can take a day, and no one will get anything done while they are there, given all the distractions. Next, and very importantly, do not interfere with the search. You can file motions later if they do anything beyond the scope. Finally, and most importantly, don't tell employees not to talk with agents. The last thing you want to do is get yourself or your company charged with obstructing justice, which the feds may do if you tell employees not to talk to them. That said, employees, like all people, do have the right not to talk to agents, and counsel can tell them that if they ask. Employees will also sometimes want counsel before talking. Consider whether to get them counsel for that purpose. The question of whether to provide counsel to individuals transcends warrant execution and provides an important point of slight departure from this lesson. When company counsel are actually aware of interview requests before the interviews happen, it's often to the company's advantage to have their people represented by competent counsel, particularly if company counsel can work with and get valuable information from the individual's counsel. Otherwise, the company will have blind spots about often crucial facts, contrary to my earlier lesson of reversing the balance of knowledge. I want to know what the witnesses are going to say. If the individuals still work for the company as company counsel, I have a right to interview them myself and find out what they have to say, as long as I make clear to them, by the way, that I don't represent them individually. But I would also like to know what they're going to say to the government, and in fact, what they do say to the government in interviews. If because of certain conflicts of interest, I can't represent individuals myself, as is often the case, I want to have the next best thing, which is talking to lawyers I know and trust who can separately represent them. I also want the individuals to be represented by competent counsel because talking to government agents and prosecutors is fraught with peril. You want those individuals meticulously prepared for interviews, and you want someone in the room who can help veer unfair or confusing questioning back on course. Even an honest, well-meaning person can say things that will be misconstrued or inconsistent with other things that person or others have said already. These risks are heightened when individuals are caught off guard, as is the case when agents knock on their doors. I had an individual client in what would have been a huge case who welcomed agents into his kitchen early one morning, where he had a dirty diaper in one hand, a bowl of Cheerios in another, and his dog was attempting to hump one of the agent's legs. Far from ideal conditions for truth-seeking, much less risk minimization. To be clear, you may never be able to avoid that scenario when agents get to the individuals before you are aware of the investigation, but the point is still the same. Thus, not only do I think it's often in the company's interest to provide counsel for officers and employees, ideally as company counsel, I want to suggest those individuals retain good lawyers who I can work with in the investigation, so long as we maintain appropriate boundaries around those relationships. This obviously presents a cost issue in paying for other lawyers. Some companies will have obligations under their charters or bylaws or state law to provide counsel for officers and employees. If you determine that you want to or need to provide separate counsel for several officers or employees, you can consider providing similarly situated individuals with what we call pool counsel, one lawyer with multiple clients proceeding with appropriate conflict waivers. This is a pretty common practice in investigations of a certain size and scope, and a good pool lawyer can provide tremendous efficient value in terms of representing his or her own client's respective interests, but also in terms of providing useful information to company counsel. Now, our fifth lesson learned from white-collar investigations. Keep your enemies close and the press even closer. For big or potentially splashy matters, develop a press strategy early, but update it as things develop. Anticipate press when something big is cooking in your organization or with someone in it. When a reporter calls, it's often too late to react properly, and people make bad decisions on how to handle press in the moment. Be sure inquiries are channeled properly, preferably to someone experienced with dealing with press in crisis situations, including especially in criminal investigations. Also, if you're a public company, consider disclosure issues. Accuracy is paramount. You don't want to put out a spark only to ignite an inferno in the form of a big securities fraud case. If other third parties are in the zone of inquiry, it's often best to let them be in the limelight while you stay in the shadows. I've managed in several cases to keep my client's name out of the papers simply by avoiding press calls and letting potential co-defendants' lawyers, who sometimes just can't help themselves, answer the same calls. This isn't always possible, but sometimes it is. A good press agent working with a good lawyer can be a formidable team. Unfortunately, I can't script what to say to the press generically, but I can offer you one fairly general principle. You can say too little and you can say too much, but less is generally more when it comes to the press. Clients rarely know how to handle this well and will often say too little or too much and often not the right thing at all. We've nearly reached the end of our presentation today. I referred earlier to internal investigations that are initiated in response to criminal investigations by government agencies. I can't possibly describe how to do an internal investigation in the time we have today, but I want to leave you with a few thoughts and questions you should consider if and when you are confronted with the potential need for one. First, right-size the investigation and make sure that the scope matches or exceeds the risk of harm. Second, outside counsel will often be hired to help conduct the investigation. Determine who their client will be. Will it be the Office of General Counsel, a board audit committee, a special committee, or will multiple subparts of the company each have their own counsel, as is sometimes the case? Be sure to memorialize these relationships in clear engagement letters, identifying clearly who the clients and their lawyers are. Third, in cases involving alleged financial fraud, will you hire a forensic accounting firm to assist? Often the answer should be yes. Fourth, whose emails will be pulled and reviewed? Fifth, who will be interviewed? Sixth, will individuals be offered their own counsel? Consider conflicts of interest and what your charter, bylaws, and governing corporate law dictate. Seventh, do you have insurance that will cover the cost of the internal investigation and/or your response to a government investigation? Review your insurance policies. Get competent counsel to help you do this. Eighth, if you're responding to outside auditors, how will you keep them informed? Will you be required to write a formal report of investigation? Most of the lawyers I know who do the sort of work that I do avoid written reports like the plague, but some constituents will insist on them. For example, different auditors approach this question differently. Some are more demanding or less understanding than others. I have had auditors who felt like they may have been misled by certain personnel at my client insist on a written report. The problem with written reports delivered to outside auditors is that the law is mixed on whether such reports, once delivered to auditors, can be protected as work product. Attorney-client privilege almost certainly is waived. And most lawyers I know will tell you that if you're forced to write such a report, you should assume it may not be protected and will therefore be discoverable down the road, either by prosecutors or by securities plaintiffs' lawyers or both. The same outside auditors that will require written reports will also likely insist on very detailed oral downloads on facts uncovered in the internal investigation, which will risk waiver of the work product protection, although the facts that you learn are not protectable. Ninth, will you report culpable individuals to the government? Under current DOJ policy, you have to do so, at least if you want to avoid having the company charged. and/or mitigate the sentence if the company is charged. How exactly one handles this process and calculus could be a presentation unto itself, and of course is highly fact-specific. 10th, thanks very much for your attention and time today.
Put yourself in the following scenario. You have just learned that someone made an anonymous allegation on your company's ethics or whistleblower hotline that senior finance personnel are cooking the books in order to present consistent and stable growth to the market. Should you, 1, begin an investigation to learn the identity of the whistleblower and reward employees who identify that whistleblower to demonstrate that he or she is simply making up the allegations to cash in. 2, bring the allegation to the attention of the CFO and senior members of the accounting and finance group and ask them if the allegation is true. And if they deny it, draft a short memo stating your findings, thus fulfilling your company's obligation to investigate. Or 3, bring the allegation to the attention of your company's audit committee chair because of the seriousness of the allegations and engage in an investigation to find out if the allegations are meritorious. The correct answer is 3. While it is tempting to investigate the whistleblower's identity or simply ask the targets of the whistleblower's allegations if the allegations are true, these approaches will do nothing but cause problems with the Securities and Exchange Commission or Department of Justice. Why is this important? The SEC brings actions against companies who engage in retaliatory conduct against whistleblowers, even if the whistleblower's allegations are not supported. Additionally, in deciding whether or how to charge a company, the SEC evaluates how a company responds to whistleblower allegations and conducts its investigation. And the SEC does not care if your company is public or private. I've been involved in investigations involving publicly and privately held companies, and the SEC treats them in the same manner. To underscore this point, the SEC recently brought some high-profile cases against privately held companies. The bottom line is this: the SEC will scrutinize the investigative process as much, if not more, than the actual investigative results. That is why the process is as important, if not more important, than the substance. While an internal investigation is a significant disruption for any company, you should spend the time and resources to do it once and right, even if the investigation finds no support for a whistleblower's allegations. So an internal investigation must always be conducted as if you will need to defend it to the SEC. Today, I'm going to give you a few rules of the road that you should consider in whistleblower-initiated investigations, starting with some general background on why the investigative process itself is important. Next, we'll discuss how best to scope and manage the issues, including why it is very important to focus on the message, not the messenger, and to initiate the investigation, including deciding who owns it and who leads the investigative efforts. Once you've initiated an investigation, I'll offer some advice on the nuts and bolts of conducting an investigation, where we'll cover the role of in-house legal counsel, how to interact with your employees, how far and deep must you go in the investigation, and the importance of maintaining the company's privilege throughout the investigation. Finally, I'll explain why your company should report the results of the investigation unless you are sure that your silence is golden. So let's get started with some of the basics. Since the passage of the SEC's whistleblower provisions in 2011, whistleblowers have become a significant source of its enforcement actions. To date, the SEC has paid over $325 million to whistleblowers in the U.S. and overseas. Under the rules, a whistleblower can collect a bounty of between 10 and 30% of penalties collected in an enforcement action which exceeds $1 million. Many of the awards have been staggering, including a single award of $60 million. Given these statistics, it should be no surprise that some law firms are devoted to finding and representing whistleblowers, and many have or will contact your employees in an effort to initiate a successful whistleblower investigation that will result in a significant bounty for that employee. I give you these stats to underscore that internal ethics hotline or whistleblower complaints which raise issues concerning accounting, disclosure, bribery, insider trading, manipulation, and retaliatory conduct towards the whistleblower will likely be escalated to the SEC. It is not for you to second guess or think that an ethics hotline complaint is not serious, or that your two-sentence response satisfied someone who is alleging fraud. The SEC brings cases against officers and directors who've learned of potential fraud and choose to look the other way. In a very notable case involving AgFeed, the audit committee chair and CFO learned that the hog production division was keeping two sets of books, and that accounting fraud was widespread, including sales of fake hogs and hogs who weighed less than reported. Rather than investigating these allegations, they withheld the information and the company reported false and misleading financial results. The SEC charged the CFO and audit committee chair with fraud for ignoring these very red flags. This means that if you see or hear something, investigate. But you may hear or see nothing. In the recent case of Digital Realty Trust versus Summers, the Supreme Court held that a whistleblower must report retaliatory conduct to the SEC and cannot rely on internal reporting alone to recover under the retaliation provision of the Dodd-Frank Act. This gives whistleblowers even more incentive to report claims to the SEC, regardless of whether they first report internally. The SEC will therefore evaluate not only what was investigated, but how the issues were investigated and dealt with. During my tenure at the SEC, I focused on how a company conducted its investigations and how it presented the results. Was it fulsome, or a check-the-box effort to present senior officers and directors in the best light possible? That experience has guided my advice to companies, board committees, and individual officers and directors I have represented over the past 22 years since I left the SEC. If you leave with nothing else today, remember this. Even if you never report to the investigation to the SEC, conduct an investigation as though you will report it to the SEC. The SEC will question your process, including how you collected documents, interviewed witnesses, and reached your conclusions and investigations. The last thing you or your board needs is an SEC attorney asking why you didn't speak to one person or examine a particular issue. This will lead to a loss of credibility and, worse yet, the possibility that you are required to reinvestigate those same issues. The investigation strategy I'm outlining will minimize skepticism and second-guessing on the part of a regulator or even your company's outside auditors. Again, the goal is credibility, and if you are credible, the SEC can, and often does, decide either not to pursue an action at all or to impose reduced penalties. So let's talk about the first rule. Focus on the message, not the messenger. When you or anyone in your organization receives an ethics hotline entry, email, phone message, or note suggesting accounting fraud, violations of the Foreign Corrupt Practices Act, manipulation or insider trading, you need to address it immediately. The first step is most critical. Treat that person with respect and communicate that the company appreciates and takes very seriously the concerns raised. Many times this messaging occurs through the ethics hotline. The message should never suggest that the concerns have no merit or that they are merely a pretext for other reasons, such as performance issues. If that person seeks to remain anonymous, you must respect that wish. If the whistleblower agrees to meet, focus on the message, not the motive behind the message. Human nature makes us naturally curious. We want to know if the whistleblower is credible or simply trying to hit a payday because he is about to be terminated for reasons that have nothing to do with the allegation. Ignore the urge to discover the motive. Several years ago, I represented a company that received a complaint from a whistleblower alleging accounting fraud. The whistleblower played no role in accounting or finance, and the company was initially skeptical about investigating the claim because it did not believe that the whistleblower was credible. However, we conducted an investigation and interviewed the whistleblower in the course of that investigation. While the allegations were not supported, we engaged in a complete investigation in the event we were ever required to defend our investigation to the SEC. On the other hand, here's an example of what not to do. The SEC brought a case against Home Street for improper hedge accounting and for its treatment of a whistleblower. It pointed out that once the company received a subpoena, it immediately took steps to identify the whistleblower. In its press release, the director of the SEC's San Francisco office summed it up best. Companies that focus on finding a whistleblower rather than determining whether illegal conduct occurred are severely missing the point. So what do you do with the allegation? If you or your team receives any message raising accounting, bribery, disclosure, controls, or insider trading issues, including those specific areas I outlined earlier, you must take immediate action. Not only can these issues implicate a company's financial statements, they can affect management representation and integrity issues. First, you should inform the company's audit committee chair. If the company is privately held and does not have an audit committee, you should raise with the board chair. A board may also decide to form a special investigative committee. The investigation should be conducted by lawyers in order to maintain attorney-client privilege and work product protection. One question is whether outside counsel or in-house counsel should conduct the investigation. In my experience, the SEC views an investigation conducted by experienced outside counsel as far more credible than an investigation conducted by in-house counsel. This is because the SEC may suggest that in-house counsel is not sufficiently independent to investigate and analyze issues involving members of her company's management. I have represented companies in SEC investigations where whistleblowers alleged accounting fraud, and the initial internal investigation was conducted by in-house legal. In all of those cases, the company had to reinvestigate issues that came up months or years ago because the SEC questioned the company's independence and response to issues raised by a whistleblower, including the completeness of the internal investigation conducted by a company's in-house counsel. As a result, my team was required to expand the scope and reinvestigate issues that had been reviewed months or even years earlier. The lesson here is not to be penny wise and dollar foolish. It is to conduct a credible and defensible investigation. Once counsel has been selected, they should meet with the audit committee chair or board representative to discuss and document a privileged investigation plan, including whether outside experts such as forensic accountants should be engaged. While an investigation is an evolving process, the plan should set forth the issues to be investigated and a plan and possible timeline for collecting documents and interviewing witnesses. No two investigations are alike. However, several issues arise in almost every investigation. 1, the role of in-house legal in an investigation being led by outside counsel. 2, issues which may arise with employees and their counsel. 3, how deep and wide must you investigate? And 4, how and why do you keep the investigation privileged? As a GC or member of the in-house legal team, your job is to protect the company. In so doing, how involved can you be in the investigation? The answer is, it depends. We've already covered the reasons why investigations raising issues that would be of interest to the SEC should be conducted by outside counsel. That does not mean you are completely walled off from the investigation. With very few exceptions, it is perfectly appropriate for outside counsel to apprise the GC of the status of the investigation. However, if the GC or the member of the team or compliance team overseeing the investigations is potentially implicated or even played a role in some of the issues being investigated, then that person should recuse himself or herself entirely from the investigation. Here's an example. If the whistleblower's first line of contact on an ethics hotline was with an individual in legal or compliance, that whistleblower may claim, rightfully or incorrectly, that the individual's response to the initial claim was either insufficient or retaliatory. To protect the integrity of the investigation, that legal or compliance professional should recuse himself or herself from the investigation of the whistleblower's claim. Even if not recused, In-house attorneys should not be involved in the day-to-day aspects of the investigation being conducted by outside counsel and under the supervision of the board or a committee. First, that involvement could compromise the independence and credibility of the investigation. If the SEC learns that company lawyers are present and asking questions during an interview, it may, rightly or wrongly, conclude that the company is trying to protect senior officers by monitoring and asking questions to elicit responses that are favorable to the company, even if that's not the case. Second, the participation of in-house attorneys in employee interviews may have a chilling effect on an employee's ability to be open and forthcoming in an interview. Every employee should cooperate in an investigation. I feel strongly that every employee manual and code of conduct should provide a requirement that an employee cooperated in an investigation. Cooperation is not limited to simply showing up and sitting for an interview. It means that the employee is obligated to tell the truth. I have seen many situations where an employee tries to outsmart the investigator. It never works out for the employee. Generally, companies are required by law or contract to indemnify officers and directors for legal costs, and many states require employers to pay reasonable legal costs for employee representation in matters concerning his or her employment. Putting the obligation aside, the benefits of providing counsel outweigh the cons. Providing counsel ensures that a witness is prepared and provides his or her best recollection of events, often with the benefit of having first reviewed documents with counsel. An unprepared witness who tries to wing it or speculate adds nothing and is in fact counterproductive to the fact-finding process. However, a witness should not be free to hire his or her sister-in-law who's a family lawyer that understands investigations. A witness should be provided with experienced counsel in enforcement or white-collar investigations who is familiar with the investigative process. Not every witness needs his or her own counsel. In many cases, one lawyer may represent a pool of several individuals with similar or aligned interests. I'm now going to turn to a very significant issue. How much do you investigate? The fiduciary duty to investigate does not mean that you need to turn over every stone, but you do need to turn over enough stones to understand the events that occurred in order to make credible investigative findings. If a document shows that an individual may have knowledge of an issue or a witness suggests that another individual may have more information about an area being discussed, a thorough investigation requires follow-up. That's the easy part. The dilemma arises when you learn of an entirely different issue during the course of an investigation. Let's take the following scenario. In the process of investigating how a medical device company accounted for and disclosed a merger, you learn that bribes may have been paid to doctors in its Latin American subsidiary. Do you, 1, ignore and push the bribery issue aside since it's not part of the scope of the investigation and will likely never be discovered in any event? 2, expand the investigation to review all payments made to doctors and hospitals all over the world, because you may as well investigate everything. Or 3, investigate the Latin American issue by engaging in email review and interviews. Let's talk about the consequences of each. Option 1, pushing the new issue aside is the easiest approach in the short run. If the company is trying to complete an investigation in order to file its financial statements by a certain date or to comply with other obligations such as a debt covenant, the discovery of a new issue complicates things. But nothing good will happen if you ignore a red flag, as the Ag Feed Audit Committee member and CFO we discussed earlier can attest. If that issue later raises its head in the course of an SEC investigation, or worse yet, a criminal investigation, the company will instantly lose credibility for not investigating it. Worse yet, if the new issue could further impact a company's financial statements, then a company could risk a restatement or further revision of its financial statements. I saw this happen twice in the course of representing 2 senior executives. In both cases, the investigating firm chose not to dig a little further when learning of a new issue. As a result, each company was required to restate its financial results twice. This all but ruined their credibility with the SEC, and in both cases, the companies were charged with securities fraud and received no credit for cooperation. It also led to a loss of investor confidence in the form of a plummeting stock price that never fully recovered. So trying to save time in the short run by ignoring issues will only hurt your company in the long run. On the other hand, there is no need to go overboard and investigate issues that do not exist as posed by option 2. Former Assistant Attorney General Leslie Caldwell referred to this tactic of investigating absolutely everything as boiling the ocean, and noted that this method can actually slow down a government investigation when the company is spending unnecessary time and resources over-investigating. Spot and investigate the issues, but don't create issues. That leaves us with the third option. Investigate the unexpected issue that arises. There may be nothing to the new lead, or it may be the tip of the iceberg, but your company will save significant embarrassment and potential penalties and fines if it investigates the issue, no matter how unrelated it may appear. Investigative materials may be subject to the attorney-client privilege, but they are more typically attorney work product because they reflect an attorney's thoughts and impressions about witnesses, documents, and analysis. A privileged investigation protects the company from being forced to disclose investigative materials during litigation that may arise out of the same facts as the investigation. In that case, your company could be forced to produce investigation memoranda and notes. The best way to protect this privilege is to ensure that privileged communications among counsel, outside counsel's advisors, such as a forensic accounting firm, are clearly marked as confidential attorney-client privilege and attorney work product. Summaries, notes, or memoranda or analysis should clearly state in the body or in a footnote that the materials reflect attorney thoughts and impressions, are prepared in anticipation of litigation, and are therefore attorney work product. But what about witness interviews? How do you ensure that they remain confidential and privileged? The established way to protect privilege involves providing the witness with a scripted upjohn warning at the beginning of each interview, even when a witness is interviewed on more than one occasion. That warning, which is named after a Supreme Court case, requires that the witness verbally acknowledge that, 1, he or she recognizes that the interviewing attorneys represent the company, audit committee, special board committee, and not the witness. 2, the interview is subject to the attorney-client privilege. 3, the privilege is held by the company and not the individual, and the company may decide to share the contents of the interview with third parties, including the company's outside auditors or a regulator, such as the SEC, without telling that individual. And 4, because the privilege belongs to the company and not the individual must keep confidential all information discussed in the interview. Another issue implicating privilege concerns the form that the investigation is presented to the audit or special committee. Should it be a full written report or an oral report only? I prefer a hybrid presentation, meaning a slide deck that is presented but not handed out during a fulsome description of the investigation. That deck may also be accompanied by hot documents discovered in the investigation, such as key emails. Sometimes the who is present during a presentation is as critical to the privilege issues as the what or how the investigation was presented. If a board member has factual knowledge of the issues being investigated, consider recusing that board member from the meeting because his or her presence could waive privilege, and that could cause significant problems if shareholder litigation follows. I'm now going to cover what is often the hardest decision you need to make during an internal investigation. Do you report the investigation to the SEC, or do you take your chances and stay silent? Two situations are no-brainers. If a thorough investigation into a matter raised by a whistleblower finds no evidentiary support, you are under no obligation to report that to the SEC or to the public. You should, however, keep the report of the investigation plan, and notes of interviews in case the SEC knocks on your door. If the whistleblower reports the issue to the SEC and the SEC opens an investigation, you can immediately point to a fulsome and complete investigation as a first line of defense. The second no-brainer comes up when the findings require public disclosure of material information. This happens when the investigation reveals that previously reported financial statements or public statements can no longer be relied upon or must be restated. It may also happen when there is a separate obligation to disclose, such as the termination of a member of senior management as a result of the investigation. In that case, the best practice is to notify the SEC Division of Enforcement of the announcement at least a day before that public disclosure, then offer to meet with the SEC staff to discuss the issues and the investigation in a manner that does not waive privilege. Since significant announcements such as a restatement or senior officer termination will likely trigger an SEC investigation or inquiry, a heads up to the SEC will give a good first impression, and it shows that your company is proactive and cooperative. As we will discuss momentarily, the SEC's view of your company as a cooperative corporate citizen will reap benefits in the long term. Before we discuss those benefits, let's turn to the third and most difficult scenario, when the investigation uncovers issues requiring remediation, but the issues are not otherwise material or disclosable. This may include one or two isolated incidents of bribery or one side letter deal which does not affect any previously reported financials. It could be a misunderstanding of or lack of clarity as how to interpret a particular judgmental area of accounting, such as in setting reserves. It may also involve a situation where the conduct at issue involves negligence but not intentional fraud and did not warrant termination or any other disciplinary action. Do you affirmatively raise any of these issues with the SEC or just sit back and wait? Not reporting what seems to be a non-material issue is a roll of the dice, particularly when there's a whistleblower involved. First, as I mentioned at the beginning, you should assume that a whistleblower is not only reporting to the company, but also to the SEC. Contacting the SEC to advise them of the investigation immediately will demonstrate proactivity and cooperation. And that cooperation could turn into the SEC's decision not to bring an action. The SEC and DOJ have repeatedly emphasized that self-reporting plus cooperation can lead to reduced or even no charges. Some key points to remember about cooperation in the context of interacting with the SEC or DOJ. Cooperation does not mean opening up everything and waiving privilege. Cooperation also does not mean telling only the part of the story you want to tell and assume that the SEC and DOJ will never learn other facts. That is even more risky than saying nothing at all. Here's a hypothetical to illustrate. In the course of an investigation, you learn of bribery issues in 2 countries, but you decide to disclose only one of the schemes. If the SEC separately learns of the other scheme, I can all but guarantee that your company will lose any credit as a cooperator, and the internal investigation will be viewed with heightened skepticism. Your chance of getting a walk or declination will all but disappear. Bottom line is that cooperation means that your presentation to the SEC or DOJ describes the issues raised during the investigation process itself, the findings and the facts discovered during the investigation. At the same time, reporting on a non-material event can lead to a no good deed goes unpunished scenario. We hope that a call to the SEC staff to report an investigation that resulted in no material finding will cause the SEC to simply hang up the phone and say thank you. But that isn't likely to happen. The SEC staff may ask that you present your findings, then spend the time and money producing documents and making certain personnel available for interviews. In cases involving allegations of FCPA violations, one self-report may lead you down the path of self-reporting every potential violation for an extended period of time. While this situation creates a conundrum, the best approach is to look at all of the facts, and in particular, the whistleblower's initial message, his or her treatment during the pendency of the investigation, and any statements that he or she may have made through the ethics hotline or in person. If the whistleblower suggests that the investigation was not thorough or that he or she was being retaliated against, it is probably best to report the investigation to the SEC. If you still decide not to report, all of the investigation material should be finalized and ready to present to the SEC in the event it opens an investigation, then subpoenas or seeks information from the company. In other words, maintain evidence of your well-documented and defensible investigation. Conduct the investigation as though you have to defend it to the SEC and be mindful of privilege. And last, decide whether it's in the company's interest to report or stay silent. Of course, there are always surprises and unexpected twists and turns during the investigation. If the investigation involves high-profile issues, there's the risk of a leak. In that case, your outside counsel should consider engaging an outside crisis management firm to assist with messaging. The investigation may also uncover evidence of criminal wrongdoing, which may require consideration of whether or not to advise the DOJ and SEC of the investigation results. Regardless of the results of the investigation, the principles that we covered today will enable you to demonstrate to the SEC that your company fosters a whistleblower-friendly environment which takes seriously, investigates, and appropriately remediates issues brought to its attention.